So our first panel will be web accountability for international crimes through the Special International Tribunal and the International Criminal Court. And our distinguished speakers will be Kostin, Didier, Reynders, Irwin, Cotler, and Beth van Schaack. I will begin by briefly introducing Andriy Kostin, dear friend and colleague, who was appointed as Prosecutor General on 28 July 2022, who also joined the National Security and Defense Council in August 2022. He has already been introduced, and I will pass the floor to the Honorable Prosecutor General to speak.
Thank you, dear Payam, and thank you, colleagues, to join this extremely important panel. Violation of basic rules of humanity would and should lead automatically to accountability. It is a precondition for political stability and restoring of the international peace and security. After the two world wars, multidimensional system of international accountability has been considered, and truly so, a source of pride of multilateral diplomacy. However, on February 24th of the past year, permanent member of the UN Security Council undertook full-scale invasion against another member of the organization. This opened the floodgates for myriad of the most brutal international crimes. To date, we have recorded over 109,000 incidents of war crimes. Russian forces have committed every crime possible. Mass killings, torture, rape and sexual violence, arbitrary detention, and forceful deportation of Ukrainians, including children, intentional targeting and bombing of critical civil infrastructure, using of means and of warfare that cause immense suffering, to name few. Moreover, we are observing how these crimes are forming a part of an inherently criminal plan of Russia to destroy Ukrainian statehood. The only possible reaction to this new reality is strong and coordinated judicial response, employing all available accountability instruments. And where there is gaping hole in international criminal justice, architecture, develop it further by establishing new institutions. Only by consolidated efforts we will be able to effectively respond to continuous blatant violations of international law by Russia, resulting in extraordinary suffering and disruption of global security architecture. Against this backdrop, the role of the International Criminal Court as a permanent international criminal court aimed at holding accountable those guilty of some of the world's most worst crimes is central. And the court has already demonstrated leadership. Arrest warrants against Putin and Lvova Belova are a clear example of this. This decision is both historical and symbolic. It sends a clear message that high political office will not constitute an impenetrable shield against legal proceedings. It is also significant that these arrest warrants are issued for crimes against children. Tens and even 100,000 of Ukrainian children have been forcibly deported from Ukraine. We already have located over 20,000 children and returned 387 of them home. However, as announced by Lvova Belova, this number could reach 700,000. These children are given up for adoption en masse, changing their data to make it difficult for Ukraine to trace them. Moreover, children are going undergoing so-called re-education aimed at erasing their Ukrainian identity and promoting loyalty to the occupiers. In furtherance, we are closely cooperating with the Office of Prosecutor of the ICC to ensure the responsibility of highest Russian leadership for other crimes, including the destruction of Kakhovka Dam and other environmental crimes, intentional targeting of critical civil infrastructure and leaving civilians without electricity and heating in winter, as well as a broad number of cases of torture and conflict-related sexual violence. The court and its specialists and investigators have our full support. Opening the ICC field office in September this year in Kiev, the biggest such structure beyond The Hague, made our cooperation even more coherent and strategic. Hereby, I want to thank to Canada and other states that have made contributions to support the work of the court and ongoing investigation of the international crimes taking place in Ukraine. Your assistance bring us one step closer to justice and accountability. I always say to all of our international partners and friends, helping ICC, you help Ukraine. Helping ICC, you are helping to restore justice for victims and survivors of this war in Ukraine. In parallel to the work of the ICC, we all should not forget that Russia's full-scale invasion of Ukraine is an act of aggression in violation of the UN Charter. Any act of aggression is not only directed against a particular state, but stands as a global threat to peace and security. Hence, stopping the aggression on a battlefield is not enough. There should be a legal response. As we all know, Russian political leadership, head of state, head of government, and foreign minister cannot be tried in foreign national courts, including in Ukraine, due to immunity and inviolability from foreign jurisdictions. This task can neither be undertaken by the ICC, since neither Ukraine nor Russia accepted its jurisdiction over aggression. Moreover, referrals to the ICC by UN Security Council would be vetoed by Russia, or I would say at least by Russia. I trust that there is a political readiness and legal possibility to fill the legal vacuum in international criminal justice and establish a special tribunal for prosecuting act of aggression against Ukraine. There are many questions being debated, different models of such a tribunal discussed. However, I would stress that 2 points are central in this discussion. First, the architects and masterminds in Russia of this crime, including the members of Troika, should be held accountable for their actions. Therefore, we do not see the crime of aggression being adjudicated on the national level or through specialized tribunal with international elements. And the process of accountability should take place at international arena to provide a solidified international legal response to this supreme international crime. Based on these 2 points, we are ready to discuss a sui generis solution to a sui generis situation that we have in Ukraine. We have already made an important step, not to leave aggression unanswered by launching the International Center for the Prosecution of the Crime of Aggression in June. ICPA, which is an integral part of the Joint Investigation Team, serves as an operational hub for documenting, gathering, and analyzing all relevant evidence. Several days ago, the US announced that it will allocate $1 million to the ICPA. This will assist us in moving forward in the greater pace in our quest for accountability. Let me finish by stressing that accountability for core international crimes is a central pillar for sustainable and long-term peace and stability. By bringing those accountable for international crimes to justice, we are not only retrospectively fighting international crimes, but are saying no to impunity and deterring future commission of such crimes. I'm convinced that with hard and laborious work, we will achieve this goal. Thank you for your attention. Slava Ukraini.
Thank you very much, Andriy. Next is Didier Reynders, EU Commissioner for Justice and Competition. Vous avez la parole.
Merci beaucoup. Et merci encore pour cette invitation. I want first to say that I've had the obligation and the necessity to react many years ago in 2014 about the annexation of Crimea by Russia and the first conflict that we have seen in Donbass. At that time, to be very concrete, we were also in the discussions about the way to react in the war and the civil war in Syria and the foreign fighters going back from Syria to some European countries with terrorist attack committed in Brussels and Paris and many other places. And at that time, with all the international partners, we have tried to engage negotiations. It was the Minsk agreements and the possibility maybe to try to solve the difficult situation by negotiations. It's totally different since last year. After the aggression of February 22, immediately after, we have organized, in the beginning of March, if I well remember, the first meeting with all the partners in the genocide network and with Eurojust to see what is possible to do to organize real investigations and prosecutions about war crimes, crimes against humanity, maybe genocide, or the crime of aggression described by Andriy Kostin just now. And just to summarize what we are doing, first of all, we try from the European Union point of view to support the Prosecutor General office, of course, because the first investigations are in Ukraine. And I remember with your predecessor, the first images of Bucha and the discussion that I had to see how it's possible to send some experts, to send some equipment to organize the investigations in Bucha, but not only there. We were together in Borodinka later to see also the situation. And so, first of all, we try to support the Prosecutor General office because there are investigations, prosecutions, and trials and convictions in Ukraine for war crimes. Second, we try to give our full support to the ICC, the International Criminal Court, and we have had many meetings with Karim Khan to be sure that it's possible to provide financial resource again and some kind of other support to the ICC. And you have seen that it was possible to start the investigations. We have now a new office in Ukraine, but also to issue 2 hours warrant. I want to describe again what was explained by Andriy Kostin just some minutes ago. So the goal is to give very large competence to the ICC. I said before this morning that we try to amend the Rome Statute to extend again the competence of the ICC also about the crime of aggression, but we are not so far. It will be a long journey, I'm sure, to do that. Then we try also to give a support to the member states and other countries doing their job. We have 16 member states of the European Union having started their own investigations about war crimes and other crimes, international crimes in Ukraine, due to the involvement of some nationals in those situations, or due to the universal jurisdiction. And therefore, we try to provide a support. But what we have tried to do is to work with our own agencies. And first of all, as Commissioner for Justice, I will say Eurojust. And with Eurojust, we have organized different kind of processes. The first one is the joint investigation team with 6 EU member states, with Ukraine, of course, with the ICC, with an MOU with the United States to be sure that we are working together in a very good cooperation between the prosecutors, because there are prosecutors around the table in the joint investigation team. Then we have amended the regulation of Eurojust to give to Eurojust a new competence to store, to analyze, and to exchange evidence of war crimes or other international crimes committed in Ukraine. It's possible to collect evidence in Ukraine, but also to collect evidence through different kind of hearings with refugees and other displaced people that we have, of course, more than 4 million till now on the European soil. And the third element is the International Center for the Prosecution of the Crime of Aggression. It's the first layer in the way to prosecute and to organize a trial about the crime of aggression. And there with the joint investigation team, we have built a real center where it's possible to, again, to collect evidence of the crime of aggression, but also to prepare with a real legal expertise the file to be presented to a tribunal. And then, of course, we are in discussions about what kind of tribunal for such a crime of aggression. I know that there are different kind of situations. I've said sometimes that the golden standard will be, again, the ICC one day. If it's not possible, I know that there are maybe some requests to organize a special tribunal. It was the proposal of President Zelensky, with a real, maybe silver standard, but we try so to find a way for the moment to have a third way. How it's possible to take the most important positive element from such a special tribunal, but also some kind of positive elements coming from the hybrid solution proposed by different actors at the international level. And we are not so far, but for the moment, we have discussed in the core group on the 16th of November in Berlin about a new tribunal organized on the principle of transfer of proceedings. So a transfer of proceedings from Ukraine maybe to the such a kind of tribunal to organize the trial about the crime of aggression. At the EU level, we are open to work on the different solutions. The most important elements, we have a broad international support. We need to be sure that we have a broad international support to do that. But of course, I fully understand also the discussions on the immunities and the so-called troika, how it's possible to have the real responsible for the crime of aggression before justice. And so we'll continue to work on it. I want just to add that about the war crimes against humanity, of course, the crimes against children are very important because we have said many times they are the more vulnerable people in such a conflict. And last weeks we have worked a lot in the European Union about the accession process of Ukraine, and we have recommended from the Commission to the European Council to open negotiations with Ukraine about the accession to the European Union. Of course, in the future, the children will be the real part of the European project. And so there we try so to see how it's possible to organize the accountability for such a crime, and with the ICC and with others, it's very important to make steps further. But the most important element is to bring the children back to their families. And on that, of course, I want to conclude saying that we need the support for all the international partners, and certainly we have discussed that just before, it's very important to have the support of the United Nations, because it may be there that there is a possible influence to organize the way back for the children. It will be not easy, but it's very important to continue to work on it. So not only accountability in such a case, but also the way to bring the children back. It's also very important. Thank you.
Thank you very much. Next is Beth Van Schaack, U.S. Ambassador for Global Criminal Justice, who has not yet been introduced. So Dr. Beth Van Schaack was sworn in as the U.S. State Department's 6th Ambassador at Large for Global Criminal Justice in March of 2022. In this role, she advises the Secretary of State and other department leadership on issues related to the prevention of and response to atrocity crimes, including war crimes, crimes against humanity, and genocide. And it gives me a special privilege to introduce her. I can say before our live audience that she was, many years ago, my intern at the International Criminal Tribunal for the former Yugoslavia, but now she's my boss, so our roles have changed. So Beth, a very warm welcome.
Thank you so much, Payam, and thank you to all the organizers for this really important gathering on this International Children's Day. This conversation is a really important follow-up on a number of multilateral gatherings called Uniting for Justice that have happened around the world, most recently in Lviv, but before that in London and in the Netherlands. And it really shows, I think, the commitment of the international community to the imperative of justice here. And I hope to use my remarks today to pan out a little bit and just map for the group here the various pathways for justice that are being pursued, where there needs to be additional work to be done, but where there are active investigations and prosecutions happening. Like so many of us here, I think I'm personally sickened as a mother, as a person, to what we're seeing happening to Ukraine's children in this war. Not only children caught in the crossfire, children whose houses, whose schools are being destroyed, family members lost, this horrible practice phenomenon of transferring and deporting children from Ukraine to Russian-occupied territory, to Russian territory itself. And also, as I mentioned during the press conference, we're seeing now the involvement of Belarus as well, and I'll get into some details there. These crimes were very much a factor in Secretary Blinken determining several months ago that not only war crimes, but also crimes against humanity are happening within Ukraine. This involves a finding that there is a widespread or systematic attack against against a civilian population. And so it's a slightly elevated standard from finding war crimes. But we know, of course, that the transfer of children and of other elements of the civilian population through the filtration program that Russia has established is a grave breach of the Fourth Geneva Convention and prosecutable as such before international and domestic tribunals. Before going into the specific efforts to address crimes against children, I just want to reiterate that the United States is standing firm in this regard, even as we see conflicts exploding and escalating elsewhere around the world. We understand that has been mentioned, including by Payam in his remarks, that justice is a long-term effort. We have to stay the course and have a degree of patience as we establish the institutions, document and collect and verify evidence, including by using very new and state-of-the-art open source investigation techniques, which we're trying to capacitate through our programming efforts. And we're also really determined to focus on all the various pathways to justice to achieve what Andriy and others have called comprehensive justice. And so in my remarks, what I'd like to do is talk about how my office, representing the United States, but also with partners, with friends through the NGO community, through civil society, are trying to strengthen 5 pathways to justice. These will benefit all victims of war crimes and crimes against humanity in Ukraine, but in particular, the children. So the main engine of justice, as we've already discussed, is of course Ukrainian courts. And we've heard from the Prosecutor General how even as the air raid sirens are going and the bombs are dropping and the missiles are arriving, his teams are still out in the field, collecting information, working in a trauma-informed way to lay the groundwork for cases. There are a number of cases that are being brought, some with individuals in custody, some under in absentia trials with very fair procedures. These cases are happening, the courts are open, they're active, and we're doing what we can as an international community to support that work. You've already heard mention by the Commissioner of the Atrocity Crimes Advisory Group, which is an effort to coordinate the donor community with respect to our implementing partners. The lead implementer is here, Ambassador Clint Williamson, my predecessor, and the deputy lead coordinator, Wayne Jordash. You'll hear from them later in the next panel to talk about the kinds of assistance that these experts are providing to the Prosecutor General. But in a nutshell, imagine the individual who helped to prosecute the siege of Sarajevo at the International Criminal Tribunal for the former Yugoslavia is now helping Andriy's team prosecute the siege of Mariupol. The second pathway to justice that we've already heard much about is international institutions, of course, with the International Criminal Court being central among them. Even though the United States is not a party to the court, we are actively looking for ways to assist the court in this investigation, including using new legal authorities that we've been given by Congress to provide forms of support, including information sharing, but also we now have the ability to potentially fund the court if funds were to be made available. And so this is a new era for the United States relationship with the court, and we're doing what we can to strengthen its ability to act upon the arrest warrants that have been issued already against the president himself, President Putin, and the Children's Rights Commissioner, Maria Lvova-Belova. That investigation, as you heard from the prosecutor, is ongoing, and we anticipate that there will be additional charges, potentially with respect to additional defendants coming forward. There are other international mechanisms and institutions at work. Just to highlight a few, of course, there's the Commission of Inquiry that the United Nations stood up. They are gathering information and putting forward public reports. It's often difficult for prosecutors to reveal information publicly because it's part of an ongoing investigation. The United States is also doing what it can to declassify information to be able to shed light on what's happening, and also empowering civil society actors. So entities like the Commission of Inquiry are important because they can do their investigations, aggregate information, and make that information available to the public, to the press, to others, to help us shape accurate policy. We've also seen the Organization for Security and Cooperation in Europe activate its so-called Moscow mechanism. It's a coincidence that it's called the Moscow mechanism, but this is a rapid reaction investigative tool that can be used against OSCE members that are falling short of their commitments, and in this case, the human dimension commitment. So there have now been 3 invocations of the Moscow mechanism with respect to Ukraine, 1 with respect to Russia and the human rights abuses that are happening now internal to Russia, particularly with respect to those who would dissent from this policy, but also more individuals involved more broadly in promoting international human rights within Russia. And then a fifth invocation with respect to the neighboring Belarus. The third pathway we've also heard a bit about, but I'll linger here a bit because we haven't been able to flush it out completely. And this involves cases that would go forward in third states. As the commissioner mentioned, the European states are increasingly interoperable now in their ability to investigate and prosecute crimes with a transnational dimension. So a joint investigative team has been created. Why is that important? It's important because it enables the prosecutors to speak directly with each other. Ordinarily, when we collaborate on transnational crimes, it involves processes of mutual legal assistance. There are treaties involved. It can be somewhat cumbersome. The diplomats get involved. That inevitably slows everything down. So the JIT allows for these prosecutors to work directly with each other. And now they're working off a shared evidentiary platform. So they have access to all the information that each other have and can start comparing notes, putting together dossiers on individuals who are responsible, thinking about strategy. How do you charge some of these crimes? The crime of aggression, for example, hasn't been charged since the World War II period. So this is why the Eurojust mechanism has become so important in order to coordinate these efforts across Europe. I'm pleased to say that the Docket project of the Clooney Foundation for Justice recently announced that they've issued 3 now petitions to German prosecutors to prosecute cases that might have a nexus to Germany or that could be prosecuted under German law. And at least one of these cases involves crimes to children. So my office, through our programming, is funding some of these efforts amongst civil society that are able to feed into prosecutorial efforts. We've seen this to very good effect with respect to the overlapping conflicts in Iraq and Syria, where civil society actors working in diaspora and immigrant communities are gathering evidence, working then with trusted relationships with law enforcement to share that information, to accompany victims through a process of justice as they testify. It's extremely difficult, and we've heard about the importance from the Attorney General and others of taking a trauma-informed approach so that individuals are not having to give their testimony over and over again, but rather doing this in a very coordinated and careful way. And many of these Syrian groups have been central to the success we've seen in Germany, France, Sweden, and elsewhere in holding Syrian and Iraqi and other foreign fighters accountable for the crimes being committed in the Syrian conflict and in Iraq. And so we want to replicate that model with respect to Ukraine by funding some of these similar civil society organizations that can then feed into formal prosecutorial processes. The fourth pathway to justice leads here to my own system in the United States, and you're very fortunate to hear later from Eli Rosenbaum, who's been appointed directly by Attorney General Merrick Garland to be his counselor in war crimes. He'll be able to talk about our war crimes accountability team, WarCat, which has the coolest name ever, my Office of Global Criminal Justice, which usually when I try and dictate says Juicy J, which just doesn't have the same appeal as WarCat. We need a better name, clearly, but you'll be able to hear more about that. But Congress has really activated itself and has drafted and expanded our war crimes law to enable us to prosecute individuals regardless of the nationality of the perpetrator, the nationality of the victim, or the place of commission. All that matters is that the perpetrator is present in the United States. One gap that we do have is with respect to crimes against humanity. Already the Secretary of State, Tony Blinken, has identified crimes against humanity being committed within Ukraine, and yet paradoxically, we do not have the tools to prosecute those crimes. And so Congress is working on that. I know that Canada has a crimes against humanity statute. I don't think it has been used yet, but at least you have the legal framework to do so if and when cases present themselves. And then the fifth pathway to justice that we're looking forward to empowering and enabling is, of course, with respect to the prosecution of the crime of aggression. It's extremely important that this crime be prosecuted here. Otherwise, as you have heard, other autocrats around the world will be emboldened to make similar moves against their sovereign neighbors. And so we need to show that the international community stands firm around the importance of protecting territorial integrity, to protecting the political independence of the Ukrainian people and other people, to protect the principle of sovereignty ultimately. These conversations, as you've heard, are ongoing. There are different models being put forth, and I'm really pleased that the European Union has been so creative in looking for ways to bridge the gap between what had become, frankly, a bit of an impasse between advocates for a standalone international tribunal that might be created through the avenue of the General Assembly. Of course, the Security Council, which has in the past created such tribunals, is foreclosed because we know that Russia would exercise its veto on any effort to establish such an institution. And then the alternative proposal that the United States and others have put forward has to do with more of an internationalized tribunal that would be embedded within the Ukrainian system, but that would benefit from significant international investment. And we've seen a number of such internationalized tribunals for Sierra Leone and elsewhere that have brought about the best of the international system when it comes to legitimacy, resources, experience, with also the ability to empower the domestic system to take the lead in prosecuting crimes committed on their territory. And so this new third way brings together some of the best of those two models. And so those conversations are ongoing. A senior member of my team was in Berlin last week to contribute our views on this. So these are the 5 pathways to justice that we're focused on. We're also trying to do what we can to bring forth information that could serve as evidence in any one of these various pathways. And a key element in this respect is with respect to the conflict observatory that we have funded through Yale University, but it's essentially a consortium of a number of experts in open source gathering of information. This involves scrubbing social media sites to aggregate information, looking for patterns within that information, gathering satellite imagery that would otherwise not be available to civil society actors at the high degree of resolution that it can be available, bringing all of this information together, putting it through big data analytical processes in order to identify patterns in responsible individuals, et cetera. The Conflict Observatory has the benefit, as I mentioned, of being able to issue this information publicly. And so in many respects, it's feeding into all of these justice efforts. And we're looking for additional ways to declassify and otherwise make information that we can gather through our own sources available to all of these various justice pathways. We're particularly concerned about a new report that the Conflict Observatory has put out about Belarus's involvement in the abduction of children. We are seeing credible information that children have been taken from Ukraine through occupied territory into Russia and then further into Belarus. And there are a number of really, frankly, creepy non-state actors that are involved in that process. This includes very far-right motorcycle gangs and others that are playing a part in this effort to remove Ukrainian children from Ukraine. So the point of my sort of mapping of these 5 pathways is to emphasize several points. 1, coordination, cooperation, and complementarity, how all of these efforts have to work together to strengthen the pathways to justice and to deliver some measure of justice to the people of Ukraine and also to Ukraine's children. So I'm looking forward to the conversation. It's great to be a part of this, this gathering.
Thank you very much, Beth. Last but not least, we go to Irwin Cotler, former Minister of Justice and Attorney General of Canada, founding chair of the Raoul Wallenberg Center for Human Rights, and a distinguished colleague and much respected mentor to many of us. Irwin, you have the floor.
Thank you, Payam. Justice for Ukraine has been a priority on the Raoul Wallenberg agenda as a matter of principle and policy, and a personal priority for myself. And I've had the pleasure of working with the Prosecutor General of Ukraine, with the Ukrainian ambassador here in Canada, with Special Prosecutor, the ICC, Karim Khan, with the core group, and others in pursuing what Ambassador Beth Van Schaack has put forward so expertly, the pathways for justice and the imperative of coordination and integration in that regard. Accordingly, a year ago, I shared with the Parliamentary Assembly of the Community of Democracies an action plan for justice for Ukraine, which included then and since the following components. First, support for Ukraine's case before the International Court of Justice, and in particular, accountability for breaches of the Genocide Convention, to unmask and expose Russia's breaches of the Genocide Convention and hold it accountable in that regard. And I'm pleased that the Canadian Parliament became the first parliament in the world to make a determination that Russia's mass atrocities constituted acts of genocide, let alone its standing incitement to genocide, which is a standalone breach of the Genocide Convention. Second, support for war crimes investigations and prosecutions by the ICC, including the arrest warrants, which have been issued by the special prosecutor and have been referenced earlier, and the importance of the International Center for the Prosecution of the Crime of Aggression and the evidence gathering therein. Third, protection for, repatriation of, and giving voice to the abducted, forcibly deported, and disappeared Ukrainian children, as Andriy Kostin has mentioned, on a scale and scope that has not been seen since the end of the Second World War. Four, Magnitsky sanctions, and I'm delighted that the Canadian government imposed targeted Magnitsky sanctions for those involved in these crimes against children. Number five, an international compensation mechanism for the seizure and repurposing of Russian assets for the benefit of the Russian people. Number six, a composite set of initiatives at the UN Human Rights Council, representations to the UN special procedure, and mobilizing to defeat Russia's candidacy for the UN Human Rights Council, which itself was part of the culture of impunity. And support for the case and cause of Vladimir Kara-Murza, the Russian patriot who was sentenced to 25 years in prison. His crime, telling the truth both about domestic Russian repression and its external criminal aggression in the Ukraine. And I happen to be the special envoy for his case and cause as appointed by the Parliamentary Assembly of the Community of Democracies, and he is a continuing looking glass into that domestic repression and criminal aggression. And the centerpiece of our action plan and our advocacy has been the proposal for an independent international tribunal for the crime of aggression in Ukraine. In September 2022, I joined David Crane, the former special prosecutor for Sierra Leone, Hans Krell, the former legal advisor to the United Nations, in crafting a proposal for this purpose, which included a draft UN General Assembly resolution mandating an agreement between the UN's Secretary General and the government of Ukraine for establishing such an independent international tribunal, and a draft model statute for the implementation and operation of such a tribunal. The whole anchored in the following foundational principles and undertakings with respect to accountability. First, that Russia's premeditated, unprovoked war of aggression is, in the words of the 1946 Nuremberg judgment for Nazi leaders, and I quote, the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole. That alone underpins our clarion call for action to combat the culture of impunity and establish a necessary framework for justice and accountability as an overriding imperative for the international community, and to do so with all deliberate speed. Second, I mention a culture of impunity because at present there is no jurisdictional mechanism for holding those involved in the organizing, planning, preparing, and executing this crime of aggression, for holding them accountable, let alone those others who have aided and abetted in this leadership crime. Accordingly, the ICC is unable to exercise this jurisdiction, and therefore underpinning our proposal in this regard. Third, the UN General Assembly has already not only condemned Russia's crime of aggression, but done so by an overwhelming majority. And just a few days ago, Switzerland announced its support for an international tribunal, joining the 40 other core countries that support this initiative, which include not only Ukraine's European allies, but also countries such as Japan and Guatemala in that regard. Number 4, such an international tribunal would act in concert with the International Criminal Court. It would be complementary to and not competing with the exemplary work of the ICC under its special prosecutor Karim Khan. And it would work closely with and benefit from the International Center for the Prosecution of the Crime of Aggression, now itself also operative at The Hague. Number 5, the EU, the Council of Europe, the Moscow mechanism that has been mentioned, the core group, have affirmed and reaffirmed their support for such an international tribunal, likening it to the Charter of the International Military Tribunals held itself at Nuremberg. Number 6, the tribunal would operate independently of the UN Security Council. It would be staffed with international judges and legal experts, providing it both with the requisite international expertise and the requisite international independence and impartiality for that purpose. In a word, the fact that this tribunal would be anchored in support of the UN General Assembly would demonstrate a shared international commitment to protecting international law, to preserving the foundational principles of the UN Charter, and to holding aggressors accountable, thereby ending the culture of impunity. May I close by offering an alternative option should the requisite UN General Assembly 2/3 majority not appear to be forthcoming. And that would lie in the establishment of a multilateral tribunal established for the crime of aggression, established by UN member states themselves. Admittedly, questions might be raised here about the legitimacy of such a tribunal and about its impartiality, particularly if such a tribunal would appear to be anchored in a Eurocentric approach. Accordingly, it would be important for the establishment of such a multilateral tribunal that it be anchored both in countries from the global north and south, and not characterized as a Eurocentric effort, but seen as an international uniting for justice. The international military tribunals, both at Nuremberg and at Tokyo, are historic examples of a coming together for this purpose. In conclusion, we have done this before, and we can do this again. Regrettably, the passage of time, distraction, distortion, division only serve to assist the aggressors. And we saw also with respect to Syria how if we do not act with that sense of urgency, the necessary mandates will not be forthcoming. And so at this point, what is required is that we be united in our pursuit of justice, united in the combating of injustice, united in combating the mother of all crimes, the crime of aggression, and that we establish this international independent tribunal with a sense of urgency that it warrants and with the justice that it can impart. Thank you.
Thank you, Irwin, and we're very sorry that you were unable to join us in person today. We now have just a few minutes, and with the permission of the panel, we will go straight to questions, either online or from the audience. Perhaps we can begin with a question from the audience. And if you could please introduce yourself.
Robert Curry, Dalhousie Law School in Halifax. I don't mean to jump up and correct Ambassador Van Schaack, but I'm very pleased to say that Canada in the 21st century has had 2 trials under our war crime statute.
Crimes against humanity. Have you done any crimes against humanity?
Yes, in fact, they were each charged with genocide, war crimes, and crimes against humanity.
Terrific. Okay.
The first guy was convicted of all 3. The second guy was acquitted of all 3. I think that means it works.
Yeah.
But what the second trial, and Payam knows as well, foundered on the fact that victims and witnesses had been questioned and interrogated and examined multiple times, which ended up meaning they were cross-examined quite effectively at trial. Credibility questions raised, and things went south from there. So I've heard a little bit about the concerns raised around how victims in particular are dealt with. I think that's absolutely fundamental. It's great to hear that it's going both from a re-traumatization point of view, but also from a practical trial management point of view. I wonder if the speaker said any comments on some of the dynamics around that.
Let me start. Thank you for this question. This is extremely important question, which, it's about changing our mindsets from the start of full-scale invasion. And I can talk about many of them, but one is particularly important. It's changing of our mindset vis-a-vis our cooperation, interaction with the victims, survivors, and witnesses of war crimes. We started to structure this change of approach, as we can name it like this, in September last year, when I created a special unit to prosecute conflict-related sexual violence crimes. And when we changed our strategic documents of Office of Prosecutor General, implying the principles of so-called Murad Code, how to interact, how to communicate with the victims and witnesses of conflict-related sexual violence. And you know that one of the main principles is to avoid re-traumatization, to avoid multiple interrogation. And with huge support of our partners and friends, starting from Pramila Patten, Special Representative of Secretary General of UN to combat sexual violence, and many, many others. So we passed through training, substantial training, not only prosecutors, but also investigators. We changed approach. We saw the rise of cases. We saw the rise of reporting. And this also showed that this change of approach really was a game changer. And starting, when I very carefully look at how this new unit was operating, I start to understand that we need fully change approach how we interact with all victims and survivors of war crimes. And you can imagine we are talking about tens or hundreds of thousands of them. And our resources are really limited. And in order, once again, to make this work sustainable and structural, I created this April in my office, Coordination Center to work with victims and witnesses. And we start to use the pilot of conflict-related sexual violence unit, the pilot experience, to extend it to all victims and survivors of and witnesses of war crimes. Now we have these coordinators there go through substantial training in many instances, including our unique cooperation with Department of Justice of the United States, really unique. So they train a lot of our staff in new directions we open, or new avenues of our work we open. And this is now our philosophy. Victim, survivor-centered approach, witness-friendly approach. We are also running through new training techniques, investigative interviews, completely different approach how to interact with victims and witnesses. And this is started and this is extending. So all investigators and prosecutors will pass through, will get this technique. And this is my commitment. This is my commitment, if not to ensure, but to start to extend the victim and witness oriented practice within all our law enforcement system, and not only to keep it for the victims and witnesses of war crimes, but in peacetime to extend it to all victims and witnesses of any crime committed against Ukrainians in Ukraine.
Thank you very much, Andriy. Yes,
Just maybe briefly to add that, of course, we have the same, first remark, the same evolution in our judiciary in general, and so in the European Union, like in the US, like in many other jurisdictions, we are doing the same, and to take into account better the victims in the process. But second, we try to support the initiative of the Ukrainian Prosecutor General Office in such a way. And third, we are doing the same with the refugees, the displaced people, because of course we collect a lot of evidence of crimes against children and other kind of crimes, so sexual violence, with some hearings of refugees. And then we have tried to promote with the member states the same kind of approach, to change the way to take into account the situation and to, of course, to avoid a second traumatization of the victims. So it's the reason why we are working a lot with video hearings, and we record hearings, and we don't ask to repeat all the time the same kind of elements about the crimes committed against children or against other kind of refugees.
Beth, any
Yeah,
last
just
words for 1 minute?
just to make concrete some of the work and assistance that the Atrocity Crimes Advisory Group that we've stood up has done is we organized some knowledge exchanges with Croatia, because of course they had a long history of prosecuting war crimes in their own national system. And Andrey's teams were able to meet with their counterparts to learn what they've done about ensuring against re-traumatization and over-documentation, standing up victim witness units. Now that unit has been stood up in the Ukrainian system. We had the pleasure of hosting them in Washington to meet with some of their counterparts under our own system. And so there's a massive sense of building and disseminating best practices here, because we have learned from the past what happens when individuals are interviewed multiple times. There's the re-traumatization point, but also the point that, little minor discrepancies will appear in written testimonies if those are taken down. They may be due to translation issues, a whole range of things. But a defense counsel doing their job, which they're meant to do, will take advantage of those to try and seed reasonable doubt in the testimony of those individuals. And that in and of itself can be very re-traumatizing to survivors, giving their testimony to be suddenly suggested that they were dissembling. And so it's extremely important that we coordinate here. So, and we've seen now as well some very important journalistic initiatives. The Reckoning Project is one, but others as well, trying to work with journalists so that they too understand the importance of not over-documenting some of these issues.
Well, thank you very much to our distinguished panel. And unfortunately, we are running behind schedule, so we will have to end now. And I would invite everyone to enjoy lunch. For our audience and delegations, lunch will be served in the Ondatier Hall. And for the speakers and moderators, it will be in the upper library. So please join me in thanking once again our panel. And we will begin at 1 p.m. sharp for our second panel. Thank you very much.